All right, so we're going to get into this private fund regulation and life cycle. That's what we're talking about. Stan's going to take the lead on talking about just the basics, right? What is a private fund? Some fund fundamentals, and then regulation overview. All the regulations involved and the intersection of those, and how you comply with those when you're starting a fund. And then I'll jump in, talk about the fund documents, some of the key terms that are in those fund documents, and then quickly life cycle of a fund, and then we'll take a break after that. So, all right, let's get started. I'll hand this to you.
Okay, great. All right, so we're here talking about private funds, and really what we're, and part of this is just kind of getting on the same page, making sure we're meeting everybody where they're at, right, Jay? So, private funds is really just kind of pooling capital to buy. In this case, and what we're talking about is pooling capital to buy securities, buy interest in companies, buy interest in tradable securities, anything like that. But it's a pooled investment vehicle, and it's we're going to find there's a lot of different securities acts that touch these funds, and it's complex to navigate it. But we're going to help you kind of just get to the high level stuff here. But that's what we're talking about here. We're talking about private funds in the sense of how money is raised, and whether or not you need to sort of take extra steps with the SEC or any governing bodies there. Let's see, this one. Yeah, some fundamentals here. We're going to be, using some terms. General partner or sponsor. You'll see this. General partner is usually the principals who have created this fund, the people kind of running the business of investing or finding deals. Management company or an investment management company. We might also refer to it as investment advisor. This is the entity that is providing investment advice to the fund or the clients there. Limited partners are the folks that you're bringing money in to execute on your purchases, and who are going to get a return on this. For the purposes of what we're talking about today, in almost all instances, that's not true. In many instances, in many applicable instances, limited partners are going to have to meet a pretty high threshold. Maybe a lot of you guys have heard of accredited investors or things like that, but we're going to be even talking about a more heightened standard for some of these folks. But these are, the types of entities and folks that might be investing in a private fund. Lastly, there'll be in the case of venture capital or private equity, there'll be portfolio companies. ABC Venture Capital is investing in XYZ startup, or private equity fund. They're buying XYZ, and they're going to roll. They're going to operate it and then eventually sell it off. So that's a little bit of the kind of overarching definitional terms we're going to be talking about. In the private fund context, we're usually looking at one of three types of funds. One is, venture capital fund. This is, fund that's investing in presumably earlier stage privately held companies that are seeking a high growth strategy, or what the SEC would just call a venture capital strategy. Private equity fund is often, buying companies, portfolios of companies, and trying to realize some efficiencies or execute on some thesis that's going on in the market there. And lastly, hedge funds. Hedge funds, oftentimes are buying more marketable securities, things you can trade. We have a client who does mortgage-backed securities, but you could buy, any publicly traded security through hedge funds. This is kind of a typical entity structure for a fund. And so at the top here, you'll have a sponsor entity. We'll create a general partner who will run the private fund. This will be, ABC Fund, LLP, or something like that, and they'll raise money from investors. And you'll see we've got this investment advisor or the management company. We set that up as a separate entity. And a lot of this is because these different entities are subject to different regulations and acts of the Securities Acts. And so we're trying to, isolate where those issues are. And then, again, in the private equity or venture capital model, you'll see, your portfolio companies. And then, if Fund 1 is a success, what you'll end up doing is you'll take this little quadrant and you'll duplicate it, and you'll keep this structure here, and you'll just kind of copy paste and create Fund 2 and general partner 2 sometimes, especially if you have, maybe a new person that's in on this second fund that you want to cut in on that. So, it's a pretty heavy structure, as you can see. I mean, it's not just one entity that we do to create a fund, but there's lots of ins and outs here to deal with. So, mentioned different Securities Acts. The Securities Act of 1933 kind of governs, issuing, selling stock, or in this case, LP interest in the fund. The Advisor Act, the Investment Advisor Act governs the a person or an entity who wants to charge money for making investment decisions on behalf of their limited partners. And then the Investment Company Act is applicable to an entity that pools securities. So again, the fund is pooling securities, whether they be privately held or not. So there's a lot to navigate. There's a lot of rules. We're obviously not going to go into all of it, but there's a lot to just kind of navigate. And as you sort of immerse yourself into the question of, do I start a fund? How do I do it? There's a lot to kind of get up to speed on at the outsets, for sure. So just to talk about some of these, regulations. The fund, going back to here, this is the fund. The fund is going to be subject to the 1933 Act, the Securities Act, when it's taking on investors. And, generally we're relying on Reg D. It's usually Rule 506B that says you can take unlimited amounts of money from an unlimited number of accredited investors. 506C allows you to kind of add general solicitations, advertisements, internet postings, widely disseminated communications with just a little bit stricter verification of accredited status. But yes, I said it very quickly, but yes, anybody in a 506B offering has to be an accredited investor. That generally means any individual is making $200,000 or more in their job. If they're married, you can get it $300,000 jointly with your spouse, and then alternatively, the typical way is $1 million in net worth, excluding your home. And then entities have a whole different kind of scheme to them, but $5 million in assets is a good marker there to determine whether somebody is accredited. A couple things I passed over here. In a Reg D offering, you can't have bad actors. Anybody who's been sanctioned by the SEC or convicted of fraud or something like that, the SEC is not going to allow that to happen without a registration. Okay, next. Blue Sky. This is complying with various state laws. In a 506B offering, the nice thing is, or 506C, we get the federal government and the act has said, well, this trumps state law, so you don't need to bother with state law. If you start getting into different offerings, you have to start to navigate a whole wide array of different state rules, and it can be rather complex. Investment Company Act. So again, going back to this, now we're talking about this is an investment company because it's pooling these securities of these companies. And there again, let's take Janus Fund. Janus Fund is a registered investment company. You can buy it on an exchange. At ABC Venture Capital Co., you can't. So there's two typical exemptions that people who are starting funds use. It's called a 3C1 fund or a 3C7 fund. 3C7 says, these investors can't just be accredited. They have to be qualified purchasers, which I believe is 5 million. Yeah, 5 million in investments, or an individual who has at least 25 million in capital to invest. So that's a pretty high standard. I have found most fund starters who are doing it their first go around are definitely focusing on the 3C1 fund, and a 3C1 fund would say, everybody's got to be at least accredited. You have a 100 investor limit, and there are certain instances in which a venture capital fund can take 250 owners, and this investor limit is a look-through. So if there's a entity with 3 people in it, it looks through and counts all 3 of those people instead of 1. So, but 3C1 is where most folks are focused, and that's raising a fund with fewer than 100 investors in it.
And one thing I would just add to that is, a lot of times we have clients call in and we tell them, all right, well, here's the deal. You got 3C1 or 3C7. And they say, well, 3C1 sounds good, but I may have more than 100 investors, so how about I set up one fund, take on 100, and then I'll just set up a second fund at the same time to take on another 50 or whatever. But there's the SEC has thought of that, so can't do that. There's integration rules. If you're doing basically the same offering to the same people offering the same deal, they're going to integrate those 2 offerings. And so if they look at both of those and you cross that 100 threshold, then you're going to violate that 3C1 exemption.
I think generally when you come up with some crafty idea to get out around the rules, the SEC's already thought of it. So.
Yeah.
Couple things to note here on the so again, now going back here, this is the investment advisor. This, as you see, this is getting, so private fund might say, hey, we're going to charge the limited partners, we're going to charge them a 2% management fee, management fee based on how much capital we raise, and then we're going to take a 20% carry once we've returned your money or returned your preferential return. So this is like the 2 and 20 model. That's what they would call it. So this entity is technically getting paid to make investment decisions on behalf of these investors. And so what the Investment Advisor Act would say is, that person is an investment advisor. They either need to be registered or exempt. And so oftentimes we're looking at exemptions, especially for a first-time fundraiser. The typical, oops, I'm on the wrong side. The typical exemptions we're looking at are, one is a venture capital exemption, and that means that the investment advisor exclusively is advising venture funds that are seeking venture capital strategy. There is some limit, some ability to get to 250 based on all this, but generally 100 is the right number to be thinking about there. The venture capital strategy, you can't have more than 20% of assets in non-qualifying investments. There's a whole bunch of restrictions on debt. So like a typical private equity fund is using debt very frequently. You can't do that in a venture capital company. There's a way to finance subscriptions and like your capital calls, but that's about it. It's a closed-end fund, meaning you can't just say, hey, my liquidity needs have changed, send me my money back. So this is a closed-end fund. And and so there's a whole bunch of other rules that we're going to get to here, but the other ones, let's see, did I miss the other ones? Okay, so there are two other Well, there's one other major exemption that I want to just at least talk about, and that's a private fund. That is, I am an investment advisor to a private fund that's not a venture capital fund, right? That is maybe buying up companies, or maybe it's a hedge fund or something to that effect. And there, before, you don't have to register as an investment advisor until your total assets under management exceed 150 million. So under 150 million in total assets, you can do this on an exempt basis. You might be exempt, but you still have some reporting requirements to the SEC when you're an exempt reporting advisor. You still have to do what's called a shortened formed ADV. This is the thing that any investment advisor has to file with the SEC to say, here's where we hold our assets, here's who our auditor is, here's how we make our decisions, here's the principles behind it, and all that sort of stuff. You get to do a kind of a reduced version of that. Once you fall outside of one of these exemptions, you either have to register with the state, depending on how big you are, or the SEC. And again, there's a whole slew of state exemptions. Some states will say if you have fewer than 5 clients, then you don't need to register. And I will note one thing here. Again, a lot of those rules say if you have fewer than 5 clients, you don't have to register. One interesting note here: you could have 100 investors in this private fund, and this is the investment advisor. The SEC will say, well, this advisor has 1 client. It's this fund, 1 client. So, let's see, where did I go now? I think that's mine. I think that's up to you here.
All right. So now we're going to talk. We'll talk back to some of those regulations as we go through these documents, but really wanted to kind of talk about, all right, so you saw the chart. Well, that looks fine and it looks complex, but there's a lot of agreements that go under it that make it even more complex, right? And so we're going to talk about some of the documents that are involved in putting together a fund. So first off, you have the fund agreement, and starting kind of from that box that said this is the fund, right? So that you're typically going to be structured as a limited partnership or an LLC. And so you're going to have an LP agreement, limited partnership agreement, or an LLC agreement. And that's going to be, a fairly complex agreement. More than, say, 3 guys getting together to start an engineering company, or, some LLC set up to buy just a single real estate investment. That operating agreement is going to look a lot different than this LP agreement or fund LLC agreement. 60 pages in length type agreement as opposed to something a lot shorter. But one question always comes up, well, where do I form it? And oftentimes it depends on a lot of things, which is, the typical lawyer answer to almost anything is, it depends. And so in this case, it's no different. But in general, if you're raising any decent amount of funds, it's going to be Delaware almost all the time. So there's, there would be maybe a situation where you're doing a real small fund and you're just located in Colorado and have a few investors where it might make sense to do a Colorado entity, but for the most part, you're looking at a Delaware limited partnership agreement or a Delaware LLC agreement. Historically, these have been done as limited partnership agreements, right? So back before LLCs became popular, all these funds were set up as limited partnerships. There's still good reason to do that today, especially if you have Canadian investors or other things like that, because certain states or certain other countries that use treaties with the U.S. on how they're taxed don't recognize LLCs as they treat them as corporations, and so then you got an issue there. And so oftentimes when you have that situation, you're doing a limited partnership agreement as opposed to an LLC agreement. But in general, if you don't have that issue, I'm often setting these up as LLCs, honestly, because I just prefer the LLC Act over the Limited Partnership Act. All right, so that's that main document that sets forth where investors come in. Then you have these subscription documents. Subscription documents are what the investors are signing to make their investment, and they make certain reps and warranties and things like that in there. The subscription agreement really says, I'm a accredited investor, or I meet some other standard that you might need for this, whether it's a qualified client or qualified purchaser standard. And it's going to have these reps in there that says this I meet those. So if I'm an investor coming into the fund, I'm gonna sign that subscription agreement and make those representations to the fund that I qualify to be an investor in this company. It's also going to have, just a little bit about what the offering is. It's going to obviously have the name of the fund. It's going to have how much, what the minimum investment is, if there is a minimum investment, what the maximum raise they're looking at. It's going to have, things like that in there. But if you're doing a fund, oftentimes you have a private placement memorandum as well, which we'll talk about. And so, the subscription agreement is really just kind of that agreement where investors are saying, I'm going to invest, I'm going to commit this amount of capital to the fund, and they sign it, and they're making these reps and warranties as part of that. Oftentimes, there's an investment questionnaire tied to that, and that's where you're going to, the investors are going to fill out this questionnaire to say, this is why I meet this standard, right? So here's all some information that you can rely on that is showing that I'm either a accredited investor, qualified client, or qualified purchaser, and I meet that standard. So that adds to some length of that subscription agreement, and also adds to a barrier to getting investors in the door, which is it'd be a lot easier if they could just check a box somewhere on an online pass-through. Yes.
There's the fund can take on some liability if somebody says they're a credit investor, but it turns out they're not, and there wasn't some verification. Is that true?
So back to the exemptions that are available. Stan talked about on the Securities Act, most of the time we're relying on Regulation D and Rule 506 under that Regulation D. 506 has two standards, 506B and 506C, that you can rely on. 506B says that you have a prior relationship with these people. You're not doing any general solicitation or advertising, right? If you can comply with 506B, then you can rely on their self-accreditation. So you can rely on that investor checking a box saying I'm accredited, or filling out the questionnaire and saying I'm accredited. If you're relying on 506C because you're using general solicitation, then what the SEC says is, and by the way, this is getting in the weeds a little bit and maybe a little dorky, but the Act, the 1933 Act, Section 4A2 basically just says it's an offering not involving a public offering. So that's the rule, right? And if you have an offering that's not involving a public offering, you don't have to register it with the SEC. And that's where the exemption stems from. It stems from the statute in the 1933 Act. But attorneys and people out there who wanted to rely on this read that and said, what the heck does that mean? What is a private offering? What is not? So they came up with this Regulation D that says, hey, if you comply with these rules, it's a private offering. And so, anybody who's been practicing law for a while, since I don't know, maybe it was 2017 when they changed the act came out to allow 506C, it's always been you can't generally solicit. You can't generally solicit because that's what makes it a private offering. And so it's kind of just a weird twist that has come up allowing this 506C to be an actual safe harbor under a statute that says it doesn't involve a public offering when you're going out to the public and advertising. So it's a weird thing for, to wrap your head around, I think, at least for me when it first came out. But 506C says you can generally solicit, but you have to take reasonable steps to verify that they are accredited, and you can only sell to accredited investors. Even though you're soliciting to everybody, it's going to be unaccredited and accredited investors out there that are going to see your offering. You can only sell to accredited investors. But the reasonable steps to verify is the hard part. So there is what you're talking about, what you probably read or a story or an article or whatever. And there was a case recently where the SEC did this to a real estate fund in California, actually. They were doing a 506C offering. They were raising the money. They had an investor questionnaire. They were supposedly checking to verify that they were accredited. Well, it turns out they didn't even read the documents that the people brought in. So some people filled out the documents, and it clearly showed they were not accredited, and they still accepted their investment. I felt bad for these guys because they had raised about 100. They had 100 investors in their. This was just a syndicated deal. It was not a fund. But they had 100 investors in there, and it turns out when SEC reviewed it, there was 4 of them that were non-accredited, and they didn't take reasonable steps to verify. SEC fined them $100,000 per person, so $400,000 fine to the company because of this violation. So that's what we're talking about. If you're relying on 506C, you have to take these reasonable steps, which they've provided some safe harbors. One is you could get a letter from an attorney that verifies that they're accredited, says, hey, I've looked at their stuff, they're accredited, I confirm that they're accredited. Two, it could be a CPA or it could be a registered investment advisor that provides that letter. Nobody wants to do that. No attorney wants to write that letter, and no client wants to pay that attorney to write that letter. And same with the CPAs and the RIAs. They don't want to do it. Or you can satisfy that by getting in things like if they're going to be accredited because of the income test, then you want to see W-2s. If they're doing it or tax returns. If they satisfy the accredited investor test because of their net worth, the $1 million standard, then you want to see, records that show either here's a brokerage account that has $1 million worth of stuff, or here's some appraisals on things that I have. Nobody wants to do that either, right? So 506Cs sound great, but they're harder to actually comply with. There are companies out there that will verify that investors are accredited, which is what a lot of people are using. But there is that conflict, right? You're going out, trying to sell investors on this deal, and then you got to ask them for all this information, and they don't want to provide it because it's confidential to them, and it makes it a more difficult process. But that's what it comes. That was a long way of answering your question. All right. So, but the subscription agreement, that's kind of where you're trying to filter this out. You want to make sure they're accredited, and you want to make sure you're complying with the rules to make sure you have an exempt offering. Next, you have a private placement memorandum, and so this is going to memorialize the deal terms and the risks involved. It's going to have biographies of the team, business plan, pro formas, things like that. Risk factors, talks about all the ways the LPs can lose their money. And it's really, I kind of talk about it as a schizophrenic document, right? Because hey, we're so great. Here's our pro formas. This is what we're going to do. Our investment strategy is locked in. There's no way, we're going to go out and kill it. Give me all your money. And then you have this, 30 pages of risk factors on here's all the ways you can lose your money, right? We may not be able to perform this strategy. This, there could be another pandemic. Anything could go wrong, right? And so it's really schizophrenic in being a sales document as well as providing these risk factors. But I tell clients, don't think of it as a sales document. It's not a sales document. People are, and oftentimes people really don't take the time to read the whole thing anyway. So, but the risk factors are there. They're in your insurance policy. It's your insurance policy to say, hey, if things do go bad and you don't have the returns that you were hoping for, and they say, God, you just, securities fraud. You didn't tell me this could happen. You're like, I told you this could happen. See page 205 on risk factors, where I told you exactly that this exact thing may happen. That's why it's there. And there's just once you get to a certain size of a fund, it just becomes, I think investors would feel strange if they didn't receive a PPM, right? They wouldn't think that you're a true fund out there if you don't have this. Now, there's exceptions to that. There's certain, I've heard of, certain well-known VC companies that have a very good track record. They don't go through the whole process as much. But for the most part, I think, my advice to clients is, it's your insurance policy. You want to have it, especially once you get into you're talking big dollar amounts. So that's what the private placement memorandum is, or people just refer to it as a PPM or sometimes an offering memorandum. All right, so that's next. Then you have the investment management agreement. That's, Stan talked about that. You have your investment advisor as part of that fund structure. If you remember the structure that was put up there, there's agreement between the fund and that investment manager, and that's going to, talk about what those investment managers' duties are, what they're going to do. They're providing, advisory and consulting services in exchange for payment. They're going to be receiving fees. There's going to be things about how that company may be fired, right? Could be fired, but usually it's affiliated with the sponsor and the GP. So this is usually a document that's not really a negotiated document as part of the deal structure, honestly. And then you have the upper tier entities, right? So all the upper tier entities, you got the investment management, the investment advisor, the one I was just talking about that has the investment management agreement with the fund. That's going to be an entity, right? So you're going to have, likely an LLC agreement for that. You're going to have the GP entity, which is likely the GP, an LLC for that has all the sponsor principals in it that, are going to be receiving what their split of the carry is. Those documents, that LLC agreement for the GP and that LLC agreement for the investment management company, those aren't really shared with the investors. Those are kind of outside of the fund. It's work that we do and help setting them up, but it's not really something that's provided as disclosure to investors. All right. All right, fund terms and concepts. So now we have all these documents that we talked about. We're going to kind of go through some of the typical terms, and mainly these are terms that you'll find in that fund agreement. And these are things, if you're thinking about starting a fund or you have a fund, these are things that you probably already know if you already have one, but these are things to think about when you're forming your fund and questions that we're asking clients when they come in the door to say, all right, well, what's the term? What are you thinking about for term? What's the fundraising period? When can you close? But we'll go through all these. So, term, especially if it's a closed-end fund, and that's what we're talking about here. If there's a term, if it's a closed-end fund, then you're going to, investors are making a capital commitment to this fund, and they want to know, when am I going to get my money back? That's their main concern. And that's whether it's a closed-end or an open-end fund. But in a closed-end fund environment, they want to know, when does this fund end, and we liquidate the assets and we make distributions to the investors. And so, typically for a closed-end fund, I'd say terms are 7 to 10 years. But, anxious to hear anybody. Please jump in and tell me if you're seeing something different or if you've seen exceptions or whatever. But in general, I would say 7, and Stan too, jump in. 7 to 10 years. Usually there's some extensions added to that say, hey, if this is a bad environment for us to sell all these assets right now at the end of year 7, then the GP can extend the fund for another year, maybe, or another 12 months to hopefully have a better environment to sell the assets, right? So that might be how it's set up. If it's a non-equity strategy, you might see shorter or whatever. I've seen shorter, even in a couple of real estate type funds. I've seen shorter periods there. All right, next is fundraising period. So again, for a closed-end fund, it's asking, how long do you have to raise this money? Are we raising money for 12 months, 18 months? How long is that period open for us to go out and raise money? I would say 12 to 18 is typical. I would say when I have a new fund manager, talking to a potential new fund manager, I'm saying, let's go on the high side of that. Unless you have these stable of investors already teed up and ready to go, maybe we go with 18 months because guess what? Everything takes longer than you think, right? And that's just, I've seen it happen a bunch of times where we've had, clients come in the door and think, oh, this is going to turn out a lot quicker, and then it takes longer to get everybody in the door and to get actual commitments made and signed subscription agreements. So I would say that's the typical range, and I usually err on giving a buffer for that. All right, so then we have investment period. So this is a separate period that we're talking about. We're talking about, and let me just go, sorry, I skipped this first closing, subsequent closing, and final closing. That's really, can you take funds on a rolling basis? A lot of times funds are set up, it says, hey, to execute on this strategy, we need at least $50 million. And so we won't have an initial closing. We're going to collect subscription agreements. And oh, by the way, going back to subscription agreement real quick, the way it goes is the investors sign it, and then it has to be accepted by the company. So they get to review all that, make sure they filled out the questionnaire correctly and they've done everything right, and then they sign the acceptance page. It doesn't become an accepted subscription agreement until they've, in a duty to make that capital commitment until that is accepted by the company. And so that's kind of how the subscription agreement works, and that goes into this, first closing, subsequent closing, final closing. You may have it set up in a way where it says, hey, we won't close on any subscriptions until we've reached 50 million in commitments. And after that, we can close on a rolling basis at any time until the final closing date, which is, that fundraising period. Whatever that drop dead date for fundraising period is, that's when we can close. But we won't even accept your capital commitments until we've reached 50 million, for example. And that provides, I think, protection on really both sides, but oftentimes it's investors who want that in there because they don't want themselves to be the only investor. I committed $1 million to this fund, and it turns out you couldn't get anybody else to invest, and I'm the only investor. And so what are you going to do with that $1 million? Are you going to be able to actually execute on this strategy? Is it worthwhile to have a fund for something like that? And so it's kind of an investor protection there, and oftentimes they want to see that. But the typical way I see it is we have some minimum threshold. Once we've hit that threshold, we can have a closing, and then we can do rolling closings until that fundraising period is up. All right, and then the investment period, that's the next kind of period that's built into these agreements. And that says, when can I deploy that capital? Because oftentimes, the way the funds are set up, it's not that you get commitments for $100 million, and then you say, all right, fundraising period's closed, everybody put in all your capital commitments, and now we're going to have all $100 million sitting in the bank account. That's not how it typically works, because one, usually there's some preferred return on that, and whoever's the sponsor doesn't want that preferred return to start clicking on that money until they actually have some place to put it. They want to put the money to work right away, so they'll have, these are just commitments out there. We have $100 million committed, and we're going to go out and find these investments, and when we have an investment, we're going to make a capital call. And we're going to say, all right, time to call that money in, and pro rata from all the investors out there who have remaining capital commitments, and we're going to use that money to make an investment. Well, how long do we have to do that? That's what the investment period is. Typically that's going to be something shorter than the life of the fund. If it's a 10-year fund, maybe you have 7 years to deploy the capital, right? And then you just have then for the next couple of years, right? You're just kind of managing those investments and liquidating them and things like that. So that's typically built in there, and again, that is an investor protection a lot of times, because they're saying, hey, if I'm committing, $5 million to this fund, do I just have to have $5 million sitting in a bank account for 7 years, or is there a time when that goes away and I don't have to, I can allocate that money to something else, right? Because these investors are earmarking their money for different investments, and one of them is for their capital commitment in this fund, in your fund, and they want to know how long they have to keep that earmarked. Next, I've kind of already covered this, but capital commitment and capital calls is basically what I've already explained, right? So the investor's making a commitment to fund, to provide funds to the fund when the GP makes a capital call. And so that's really how it works. The commitment, kind of already talked about, getting a little redundant here, but the GP commitment this is the GP commitment. GP commitment is, how much is the general partner going to commit to invest in the fund? Do investors want to see that GP has money in the fund as skin in the game, right? And so that's often a selling point. Hey, come commit capital to my fund. I have my money on the table too. I'm investing in this strategy as well. And so, different investors are going to care about that or not. I've seen limited partners that require that the GP have some money in there, right? They're saying, hey, I'll invest, but there's got to be some GP commitment. Is that 10%? Is that, something like that? A lot of times it's 10% is what I see, but I don't know. Do you see?
It varies.
Varies, yeah. And, sometimes, especially with new fund managers, it's, well, I'm going to raise a decent fund here. Do I have that even 10% ready to commit? And so maybe I need to go out and raise money as a GP fund to invest into this other fund, right? And so, that happens too. But I've actually seen a little bit less, requirement on GP commitments, I think, recently, especially, it's really just the sales process, right? Can you sell to the investors without that? And if you can, then all more power to you. Next is capital call default. So, hey, it's easy for me to sign a piece of paper and say I'm committing $5 million to this company, but whether or not I actually have that $5 million is another question, right? Or if I have it, am I going to have that 3 years from now? And so really, in the beginning, if you haven't made a capital call yet, then there's not a lot of recourse, honestly. Sometimes the agreements are set up where you can sue them. You could sue them for specific performance, sue them to put in their money. But I've never seen a GP actually do that. Never seen somebody say, all right, I'm going to sue you because you didn't put in your capital call. So what you do is you build in big penalties for these people if they don't. So once you've made some capital calls and they have money in the fund, and say you've deployed, you have a $50 million fund and you've deployed 20 million of it, and this investor has put in 5 of that, but they still have a remaining commitment of 5 million, let's say. Well, you can go to make a capital call and It's a bad market. They don't have the money. Say I can't make my commitment or can't make the call. You have very punitive penalty provisions in the operating agreement that's going to dilute their percentage that they do own. And that's oftentimes what you see is them either finding a way to sell their interest or finding somebody else to put in the capital contribution. But oftentimes it's up to the GP too. So it's tough. This is a tough situation, I think, for GPs to be in, because they've gone out and they've built relationships with these investors, and they don't want to go to them and dilute them, right? Because then for sure you're not getting another investment from them, and it doesn't feel good. And so usually it's at the GP's discretion of whether they actually go through with that dilution. And luckily I haven't had too many clients where we've had to really run into that. And when we have, I've noticed that GPs have been more lenient on them and try to figure out a way to figure it out so they didn't get crushed in the dilution penalty. But that's one thing that's not on these slides is conflict of interest, and that's kind of a conflict of interest because the dilution to that person really helps all the other LPs, right? And so you got to think about conflicts of interest. You need an attorney. All right, so more fun concepts. We're running low on time here. I'm sorry I took a little longer probably on my 506C story, but we're gonna we'll go quickly into this. So other terms, right? Economics, management fee, waterfall, and carry. Everybody's heard of you got a 2 and 20, right? So taking 2% management fee, I'm taking a 20% carried interest. That's a pretty typical out there, but it depends. I've seen also new fund managers who don't take fees. We're not going to take a fee. And I've also seen fund managers who say, especially if they don't have a lot of infrastructure that needs to take that management fee to continue to pay their staff and employees, because that's what that management fee is for a lot of times. I am a fund and I'm a business, and I have employees, I have analysts, I have people who are out there doing stuff, and I have to pay them. So how am I getting money during the period when we're not liquidating assets and getting that carried interest? Well, it's that management fee. If you don't have all that infrastructure, I've heard people say, well, I'd rather just put it all back into the carried interest, right? I'd rather bet on myself on this investment strategy and just put it, no management fee, but I'm going to ask for a higher carried interest, right? And if you don't have that infrastructure, maybe that works. But that's really the management fee piece. I have some notes about a management fee waiver, which can sometimes happen where you waive that management fee and do turn it into carried interest. The IRS hates it. They're trying to figure out a way to stop it. But that's something that's a little bit more, I guess, too in the weeds for 2 more minutes of presentation. Carried interest, you have American Waterfall, European Waterfall. You might hear those terms. American Waterfall is a deal-by-deal fund. European Waterfall is a return of the whole fund before you get that carried interest. And so, I would say, especially for new fund managers, it's harder to get that deal-by-deal setup. If you do have a deal-by-deal setup fund, then that goes into our next bullet point is almost always there's a clawback because, your first 3 investments could be home runs, and then your next 10 could be complete losses. Now, you've taken a carried interest on these first 3 investments and made money as the GP, and then you've lost all the rest of their money. And so they haven't even got their capital and preferred return back as the investors. They're going to say, all right, we're going to claw back. We're going to claw back some of that carry that you've had. All right. And then, key person events, sometimes that just means, hey, who is the head, the principals of the GP? What if they die? What if something happens? What if they commit fraud? These are events that will either take away some of that carried interest or allow them to remove the manager, things like that. What else do we want to talk about? Side letters. Side letters come up often if you have a big investor and you want to, you got to give them a different deal. It's always another conflict of interest, tricky situation, but those often come up. Let's see. Life cycle of a fund. Not much to talk about here. This is really just kind of as you might expect. You got to first come up with the idea. What's your investment strategy? What you're going to do? Put together your team. Go out there and form the fund. Do the fundraising. You launch the fund by going out to investors. You got your investment period, your capital calls, all that operation and reporting, and then you exit, right? Wind down the fund, make your final distributions, and liquidate. So that's really the life cycle in a very whirlwind tour fashion. So we're right at the time. Any questions? I guess right now we'll take some time. If there's a couple questions, we got a break coming up. So if there's any questions, we can ask that at the break too. So, all right. Well, thanks, guys. We'll take a 15-minute break, and then we'll get into the next presentation.